Okay, shall we start? Okay, good evening.
Yeah, I'm ready.
Thank you very much for joining us today. These webinar series on behalf of Young Professional Society. We have a very important webinar today on intellectual property. As you all know, that the Young Professional Society has been set up to help and support youngsters with personal and professional development. So our focus is on 3 areas. Please, if you could mute your mic. Okay, so Young Professional Society, we focus on 3 areas. Number 1, communication. Number 2, leadership. And number 3, innovation. So we've been running a number of webinars under these 3 pillars. We've had scientists, we'll have lawyers, surgeons, and people from different professional people who are coming in and speaking about their profession and about their field. And the aim is to help youngsters. And innovation is one of the pillars that we work under. And we've had entrepreneurs who've come in, who've set up companies, and there's a lot of youngsters who are interested in entrepreneurship, in innovation and creativity, and they want to set up businesses and companies. However, it's very, very important that they know about IP, intellectual property. And we're quite fortunate to have a youngster with us who will be speaking today, who is someone who graduated recently, did his biomedical science. He's a first-class student, first-class honors student, and then he went on to Queen Mary's University to study intellectual property management. And at Young Professional Society, we would like to provide a platform for the youngsters so that they develop their leadership skills. And I think this is an excellent opportunity for our speaker, for the young person who will be speaking, and hopefully he'll be developing his leadership skills. And I'm honored and pleased to have Mohammad Hassan with us today, who's from Manchester, and he will be speaking about intellectual innovation and intellectual property. So Mohammad will speak for maybe half an hour to 40 minutes. And those people who are watching us on Facebook, and if you've got any questions, please do type in your questions in the chat box. Those people who have joined us on live on Zoom meeting, if you've got any questions, please do type them in the chat box, and then we will hopefully all the questions will be answered by Mohammed after his talk. So without further ado, I'll pass on to Mohammed. Mohammed Hassan.
Yeah. Okay. So, sorry. Good evening, everyone. My name is Mohammad Hassan. Thank you for introducing me. So yeah, like Dr. Nasser Ali said, I have a undergraduate degree in biomedical science, and then I did my master's in management of intellectual property from Queen Mary University, and hopefully I want to, my aspirations are of becoming a patent attorney in the life sciences and biotechnology field. So this is my PowerPoint presentation to you today. So the title is Innovation and Intellectual Property. So what we're going to be doing is going through the basics of intellectual property law, because it is a very, very big area of law, and there's a lot of things inside that come under intellectual property, and it's very it's a wide topic. So we'll just be going through the basics, because obviously there is a lot of things to mention. So hopefully let's start. So the definition of intellectual property, let's start really basic. So the Cambridge English Dictionary says that the intellectual property is defined as someone's idea, invention, creation that can be protected by law from being copied by someone else. So that's a really basic definition. So it's basically any idea or invention or creation. Although we'll see later on that this definition may not be 100% accurate, because ideas cannot be patented. But we'll see that later on anyways. But for now, let's just really basically, it's an invention or recreation that is protected by law and can be copied. It stops others from copying this. So then we look at the UK government website. So the UK Intellectual Property Office. They say intellectual property is something that you create using your mind. For example, a story, an invention, an artistic work, or a symbol. So if you think of intellectual property, because when you say intellectual property to someone, they think houses and flats and all this sort of stuff. But intellectual property is the property of your intellect. So what your brain, if your brain can think of a new invention, this is your intellectual property. This is a property that belongs to you and your intellect. So we'll carry on. And what is IP protection? So IP protection is, it stops people from stealing or copying your invention. So this can be the names of your products or brands, your inventions, the design or look of your products. So even packaging and stuff can be protected under intellectual property. Things you write, make or produce, so books, etc. And we'll be looking at this in more detail now. So the main types of intellectual property. So the main focus of this PowerPoint presentation will be patents, but we'll also look at trademark and copyright and designs in a little bit of detail as well. So we'll start off in reverse order, because in my opinion, copyrights are the easiest to understand, then trademarks, and then patents. Patents are hard to understand in a sense. So you own intellectual property if you yourself have created it, and obviously it meets the requirements for one of the branches of intellectual property. You can even buy intellectual property rights from the creator or a previous owner, or you can have a brand that can be a trademark, or even a well-known product name could be classified as intellectual property. And we'll look into this, like I said, in detail a bit later on. Intellectual property can actually have more than one owner. It can belong to people or businesses, and this is, if you think about it logically, most intellectual property is owned by businesses. So there's big pharmaceutical companies, big computer science companies that own softwares, and they own patents in, biotechnology and stuff. Intellectual property can be sold or transferred as well. So if I own a patent in a medicinal product, I could possibly sell this and make a huge profit over it. And obviously, intellectual property can generate money. So we just touched on that before. So like I said, we'll start in reverse order, starting with copyrights. So copyright protection. So I'll just list the things that come under copyright protection. So in short, it's just musics, films, books, sound recordings, television recordings. So this is the official list on the Copyright Act. So it's original literary, dramatic, musical, artistic work, including illustration and photography. So this has just been added recently, the illustration and photography. So any book you write, any music you create, any artwork you create, you can get copyright protection for that. And now, more recently, there's been non-literary work as well, such as computer software and web content that can be copyright protected, sound and music recordings, films, broadcasts, etc. So copyright protection comes into force automatically. So if someone writes a book and they know nothing about copyrights in the UK, they know nothing about it, they will still have copyright protection. There's no application, there's no fee needed, and there's no register for copyrights either, as you'll see there are in trademarks and patents. So yeah, like I said, if I create a book or if I make an artistic work, I have copyright protection over that. So this prevents people from copying my work. So let's say I created a book. Nobody can copy my work now, even though it may not be published and I know nothing about copyrights. I've not applied for copyright protection. I will still have intellectual property over this book. So the copyrights, they prevent people distributing copies of the work, renting or lending copies, performing, showing or playing the work in public. So if it's a drama, no one can, perform this drama without your consent. So you can stop people from performing it, making adaptation or placing the work on the internet. So that's copyrights. That's very basic copyrights. But like I said, in this lecture, we'll be focusing most on patents. So then we move on to trademarks. Trademarks are a bit harder. But this is paraphrased from the UK Trademarks Act 1994. But before I say that, I'd like to paraphrase it myself. A trademark is any sign that indicates trade origins. So any sign that basically reminds the consumer that this product originates from this company. That can be a trademark. So the UK Trademark Act 1994, that defines a trademark as any sign that can distinguish the goods or services of one undertaking from those of other undertakings. So in simple words, it can distinguish, it's a sign that can distinguish the goods from one company to another company, and it can be graphically represented. So it gets quite complex from here, so I won't delve too much into it, but graphically represented just means that it can be, so in order to put it on the register, you would have to either draw it out or in any way it needs to be graphically represented. So then we go on to what may constitute a TM, a trademark. So we'll just use TMs for now instead of trademarks. So if copyright protects books and artistic works, trademarks consist of words, designs, letters, numerals, and they can even be a color, a sound, or shapes, or even their packaging. So for colors, if you remember the Orange company, they trademarked that sign and included the color as a trademark. So that's very more difficult, but mostly it's words. So Specsavers have a trademark on the word Specsavers, and they have a lot of case law with them, even letters and numerals. So yeah, that's what trademarks can consist of. So the requirements of registration, a trademark must be distinctive and it cannot be descriptive. Because obviously if a trademark is descriptive, you cannot have a monopoly over something that is descriptive, because that descriptive word should be open for everyone to use. So if you have a descriptive word, if a trademark was to be done on a descriptive word, you can basically sue everyone for using a descriptive word. So that's why a trademark cannot be descriptive and it must be distinctive. So the best, the easiest way to get a trademark is to have a completely distinctive word, or even a made-up word. So, for example, we think of Google is a made-up word. So that's why the trademark was applied to Google and Yahoo, etc. So the more distinctive the word is, the greater the chance of getting trademark protection. Like I said, trademarks must be capable of graphical representation. We won't delve into this too much, but there is a lot of case law regarding graphical representation. It basically means that you need to put the trademark graphically to be onto the trademark register. And the test of registration is that distinctiveness must be assessed through the eyes of the average consumer who is reasonably well informed, observant, and circumspect. So in trademark law, this average consumer is a very big figure in trademark law, and we'll go on to that in a bit more detail now. So there's two ways a trademark can be refused registration. So we look at absolute grounds, and then we'll look at relative grounds in the next slides. So basically, absolute grounds is basically that the sign does not fall into the definition of a trademark. So anything that cannot constitute a trademark is obviously not able to become a trademark. So if a sign is non-distinctive, or it is descriptive, or it is generic, it won't be registered as a trademark. Here's another one. This is quite specific as well. If it's a shape or any other characteristics resulting from the nature of the good themselves, or necessary to obtain a technical result, or if it gives substantial value to the goods, this will not allow for trademark registration. Like I said, it gets a bit more technical now. And the last one is if it's contrary to public order or policy, or if it deceives the public, or the application was made in bad faith. So this is like ethical issues regarding trademarks as well. And then the relative grounds for refusal of registrations. This is basically if there's a sign similar to it already registered, then anyone can bring about relative grounds for refusal of registration. These are three types. So basically, I've not written much about it, but double identity is when the sign is identical and the goods are also identical. Likelihood of confusion is basically similar or identical signs or similar or identical goods and marks with a reputation. This constitutes dilution and tarnishment of the mark. So if there's a mark that's registered and another person uses a similar mark that tarnishes the earlier mark, then it will be refused registration. And then let's talk about infringing acts. So that we refer to the Trademarks Act again. Infringement is when the new mark was. So these are the four. Is it four? 1, 2, 3. Yeah, four. So these are the four objections. So the infringement, the new mark has to be used. The infringement must be used in the course of trade. So it needs to be in a commercial settings, in the relevant territory, in a way that affects one of the functions of the mark. So if these four conditions are satisfied, then that constitutes infringement. So that's trademarks done. The main focus of this seminar was webinar was patents. So what is a patent? So a patent is a state granted monopoly on an invention for a limited amount of time. That's a very basic definition of a patent. So it's a state granted monopoly, which means it comes from your state or country, and it means you have a monopoly over an invention. So only you can do certain acts regarding that invention for a limited amount of time. So it grants the proprietor of the patent the right to stop others doing things in relation to that product or process, for example, making the product or using the process. So patents are territorial. So if you apply for a patent in the UK, then that patent only is enforced in the UK. So in other parts of Europe or in parts of Asia or any other place that's not the UK, the patent is not enforced there unless you make an application for the patent in that area. So just a bit of history, just a few quick facts. The first known patent for an invention was granted in 1236 for woven fabrics. So you can see patents have been around for 800 or so years. The first known English patent for an invention was in 1449 for stained glass. So in the UK Intellectual Property Office says either that was the first patent or in 1440 for manufacturing salt. So that was a process patent. So the basic requirements of a patent, so this is quite important. So anyone looking for a patent, these are the four main things. The invention has to be new. So this is what we call novelty in patent law. It involves an inventive step. So this means there is an invention involved and it is not obvious. And we'll look into this in more detail. It is capable of industrial application, so it can be used in the industry, and it is not part of this excluded subject matter. And then that's a list of things that can't be patented, but we won't look into that at the moment. So the patent application. So unlike copyrights, a patent has to go through an application, and this application can take many years. So it's a long process, and it's not easy. So the application, you need to obviously request for the grant of the patent. You have to describe the invention. You have to describe the claims of the invention. So what the claims mean? The claims, basically, in simple terms, claims are the new aspects of the invention. What protection you're asking for. Any drawings you can include, and an abstract is basically, in simple terms, what your patent is. So in the UK, a patent lasts 20 years from the date of filing. So once you file the application for the patent, you now have 20 years from that date, that if your patent is successful, it will be in force for 20 years from the date of filing. And the patent has to be renewed every year from the 4th year, provided that it is successful. So from the 4th to the 20th year, your patent has to be renewed, and you have to pay renewal fees. And this varies. I don't know the exact figure, but it can be costly. So this is something you have to bear in mind whether when you want to apply for a patent, is that it brings about yearly fees. So we look into these in more detail again. So novelty, the invention has to be new. So there's a few terms I'd like to discuss. So prior art is anything in the public domain before the novelty of the invention that is assessed. So if you want to patent a product, ideally there should be no prior art. So this is what we call prior art. Prior art means anything in the public domain that can anticipate the invention. So if prior art exists, this will anticipate the invention. So anticipate is another word we use, and the invention will therefore not be patentable. So basically, your invention has to be new in every sense of the word, and it has to be novel, which is the word we use in patent law. Your invention has to have a inventive step, i.e., it must not be obvious to a skilled person. A skilled person is another thing we need to look at. It's similar to the average consumer in trademark law. So in trademark law, you have the average consumer. In patent law, you have a skilled person, and we will look into this further on. What constitutes a skilled person, and you may be shocked with what I would be about to say. So the basic test, it stems from case law. So you need to identify the notional skilled person. You need to identify the relevant common general knowledge of that person. You need to identify the inventive concept of the claim. You need to identify whether there is any differences between the prior art and the inventive concept of the claim. And then, are these differences, if there is any differences, are these differences obvious to the person skilled in the art, or does it require a degree of invention? So that's, in very basic terms, what the test is for inventive step. So in simple words, if I try breaking it down, that the new invention and anything in the prior art must not be obvious to a person skilled in the art. Okay, so we will look at this in more detail now. So the question of obviousness has to be assessed through the eyes of the skilled person, but non-inventive man in the art. So this is going into quite a bit more detail now. So the skilled person, like I said, you may be shocked, is not a real person, but he's a hypothetical addressee. So he's a legal creation. He's not a real person. So it's basically the the application will be assessed by a fake person. Basically, it's not a real person. But if you read this paragraph here, it's from one of the case laws. It is quite funny what constitutes a skilled person. So he's deemed to have looked at and read publicly available documents, and he knows public uses in the prior art. He understands all language and dialects. He never misses the obvious or stumbles on the inventive. He never thinks laterally. He differs from all real people in one or more of these characteristics. So the person skilled in the art, I think this comes from the Pfizer case. Yeah, it's just basically a legal construct that is created for every patent application. So the court devises a hypothetical person that would be skilled in the art that the patent application is filed for, and then you need to judge the common general knowledge of that skilled person. So I've listed a few things there, but I won't delve into that too much. So the inventive concept of the claim, the base of the inventive concept is the claims itself. So that's step 3 for inventive step. Step 4 is you obviously identify differences between prior art and the inventive concept of the claim. So you identify the gap between the prior art and the invention. And step 5 is simple, is are these differences obvious? So that's novelty and inventive step looked at. And then we look into infringement in patents. There's direct and indirect infringement. So for direct infringement, the patent must be enforced. The act must be done in the UK. The act is done without the consent of the patent proprietor. So if I have a patent and someone infringes it, my patent must be in the force. The infringer must infringe in the UK. So we're talking about the UK at the moment. So this can be any area or country basically. But yeah, so in the UK, the act must be done in the UK, and this act will be done without my consent as the patent proprietor. So uses here will define what specific acts constitutes a use. So if this person makes the invention, disposes of the invention, offers to dispose of the invention, uses the invention, or imports the invention, all of these constitutes patent infringement and direct infringement as well. I've listed here that the infringing act does not need to be in the course of trade, unlike in trademarks. So it could be done privately. So if I privately use someone's patent, that still constitutes trademark infringement, whereas patent infringement, whereas in trademark infringement, so let's say if there's like I mentioned Specsavers before, if I write Specsavers on a sheet of paper, that is not trademark infringement. But whereas for a patent, if I use a patented invention even inside my own home, that constitutes an infringement. Then we go on to indirect infringement. This is basically someone other than the proprietor of the patent supplies or offers to supply the invention in the UK to an unlicensed person. This is infringement as well. So this is not direct infringement. This is when you're just facilitating the use. Even though you might not use it yourself, you're facilitating the use. So you supply, or even if you offer to supply. So let's say there's a patented product, and I offer a company this product. So I would be indirectly infringing this patent because I'm offering to supply this product. There's few permitted acts in patents as well, and there's a whole lot of case law on this as well. But obviously this is very basic. Private and non-commercial use. So personally, I find this a bit contradicting because in the beginning we said private use would constitute infringement, but in some circumstances private use may not constitute infringement. Experimental purposes relating to the subject matter of the invention. So if you're trying to improve the products, this may not constitute infringement. And also research. So most of these permitted acts actually are done within the pharmaceutical industry. That's another point to note, that if the pharmaceutical industry as a whole has more permitted acts than any other industry. And now patents and innovation. So the justification for patents, there's two main ones. Is economic justifications, that patents provide an economic incentive to invent. If there was no patents, then the inventor would not get a return on his invention, as it could be copied by anyone. So this is the main thing. So patents can bring about millions and millions of pounds. There's prizes, there's all sorts of stuff. So patents are the strongest justification for patents is the economic justification. So this is why countries have patent law in place, is to basically provide an economic incentive to inventors, so that if they invent, they can basically gain a lot of money from it, because others cannot copy that invention. And there's moral justification, is that basically this is another justification. And bear in mind, these justifications do have opposing sides to it as well. So people often state and they rebuke these justifications as well. So these justifications, even if it is a justification, it doesn't necessarily mean it's correct. But this is what governments, etc., use for patent law. So the moral justification, there's a lot of case law on this as well. So the main one is natural rights. So this argument states that the labor of a person should be the property of that person, very briefly. So when we look at economic justification, I'd just like to mention as well, I've not included it in this PowerPoint, but my dissertation during my master's was basically, do patents impede access to medicines in developing countries? So basically, in the pharmaceutical industry, I looked into HIV and AIDS, and how there was patents were basically impeding access to medicines in mainly South Africa, because it was hiking up the prices so much that the average person could not afford these medicines. And this was partly due to the patents. So I did write a dissertation on this, which I looked into that. So what my personal findings were was that although patents will rise up the prices of medication, it's not the sole reason why the prices are hiked. There's a lot of other things that affect the price. What I'll do is I'll just see if I can just find my conclusion. So basically, although patent protection on medication does rise the prices, it's not the sole reason for the price hike. There are countless other factors that raise the price of medication and therefore hinder the access of medication to people in less favorable conditions. And even in developed countries, it might impede access to medication. And in my conclusion, I stated that this is a very big discussion, and there's lots and lots of things to consider. And in patent law, we have it's called flexibilities. So there are a few flexibilities in patent law that are effective in reducing the price of medicines and to basically increase the supply of low cost and generic medications. However, these flexibilities are not really how should I say it? They're not very developed. So there's a lot of ins and outs and a lot of gray area where a lot of things are not known. So these flexibilities need to be stamped down, written word for word in the law so that we know what we can do and what we can't do. So what I also found was that these flexibilities, there have been numerous revisions to these. So year by year, the flexibilities are basically helping the cost of medications to go down, and they are a great method of preserving IP rights whilst also helping others, to afford medicines. And yeah, that's pretty much it. So hopefully that was a brief overview of intellectual property and innovation. And yeah, if you have any questions, I'm free to answer within my limited knowledge.
Thank you very much, Hassan, for an excellent presentation.
No problem.
Maybe if you could, I've just noticed you've not turned your camera on. If you could do that, at least.
Okay, I'll turn that on now.
Yeah.
Yep, sure. 1 second.
Yeah, as I mentioned in the beginning, if there's any questions and people are watching us on Facebook, please do type your questions there. And also those people who've joined us on Zoom meeting, if there's any questions. And I believe that there is a question here. What can a small inventor do if they can't afford IP protection?
From my knowledge, I don't think there is much you can do. But what we actually say is that if you can't afford it, then I don't think there is much you can do, to be honest. But once your patent is enforced, you will more than likely be gaining a lot of money from it. But if you can't afford it, then I think it's just, I'm not too sure. You probably have to go on Dragon's Den or something to get some backing from the big guns. But once your patent is enforced, then there is a lot of money to be made from it.
What about if a youngster is doing some work? It might be some
Mhm.
technical work, some scientific work, some work in the lab or so, and
Yeah.
they think that they've developed something that's novel. Yeah, they're not too
Okay.
sure, but they think that there's some novelty there.
Yeah.
Who do they approach? Who do they need to go and see some lawyers, some special lawyers, or
Yeah. So
just to make sure?
yeah. So they see a patent attorney, which is hopefully what I want to become one day. So the patent attorney will basically guide. 1 second, this has gone off. Yeah, the patent
Yes, I
attorney
can hear
would
you.
Oh yeah, no problem. The patent attorney would basically guide the person who's making the application, basically A to Z. They cover everything that's anything in relation to the patent. So making the application, they may even tell you that your application will not be accepted, so there's no point of going ahead. They may give you guidance as to how to improve it. So yeah, it's a patent attorney that you need to find. But if, like you said, if you're a young inventor and you're working in a lab, even before contacting a patent attorney yourself, it's probably best to contact the company you're working for, because more than likely they will have an in-house patent attorney already within the company, who will obviously assist better than a private patent attorney. So if you are a young inventor and you believe you've got something that is patentable, then the best approach to take would be to contact someone in the company, maybe not disclose the invention, but ask them if they have a in-house patent attorney, and they can take it from there basically, and guide you as to whether they think the invention is patentable. Yeah, and they'll take it from there, and any infringements and stuff, the patent attorney can take care of that for you as well. So if there's any infringement, you know, you can win a lot of money in that case, if you can prove damage and stuff.
And then again, if someone's working in the lab and they're doing some work and there's some novelty there, but they just publish some of their work or so as a rapid communication in some scientific journal, does that mean because it's something's published, even a part of a small part of the work, which is novel, is being published, does that mean you can't really go for a patent application?
Well,
Or
yeah, so that's what the patent attorney will tell you. So he would ask you if you have come across any prior art, is called. And if there is, then it just depends on how much information has already been provided to the public. So we do say if it's not even necessary that someone has seen this, as long as it is available to the public. So you know, you could put it on a website that has literally 0 views, but because it is on a website, it is available to the public. This may, the patent attorney would basically look into whether this can affect your application. So it is obviously very intricate matters, and it goes on a case-by-case basis. It's not, you can't say straight away that, you know, it is, if it basically will 100% stop your application from going through, but you know, like I said, it has to be looked into on a case-to-case basis.
okay. Coca-Cola, yeah, Coke protect their recipes by keeping it a secret. Isn't that the best option and much cheaper than patents? Keeping something secret.
So to be honest, I've not come across a recipe as being patentable. So in that sense, I don't. It's a very good question, to be honest, and I don't know enough whether that would constitute an invention. It won't be a trademark, and it's obviously not a copyright. But it is a very, very good question, and you need to ask someone more senior than me whether a recipe can constitute an invention as such. So Coke, they have a secret recipe. Yeah, so it's a good question, but I don't think it could be patentable, a recipe.
But
But that's a
yeah,
good question, and
yeah, in some countries, IP laws are very relaxed. Yeah, and you can't get any protection. What can you do in that situation?
um,
I mean, if you live in,
I
say,
think most companies, yeah,
I mean, if you live
I
in,
think
say,
most countries do have. Yeah, I understand what you're saying. Most countries do have an intellectual property office. It's whether it's basically up to scratch. But what you can do is there's also the World Intellectual Property Office as well. So you can get a worldwide application, but then obviously that's much harder to get. So if your country, unfortunately, if it does not have a good patent office, then there's not really much you can do about it. What, you know, other things you can do is get a patent application in another country. So if there's a neighboring country with a good patent office, or so in the UK we have the UK IPO, then we have the EU IPO, so the European Patent Office, and then we have the World Intellectual Property Office as well. So, but obviously it gets harder and harder. So the bigger your jurisdiction, the harder it is for your patent to be in force.
okay, yeah, we've got some youngster here who's Maha, who's asked that how does one get their foot into a firm that specializes in IP, intellectual property? Where does one start? Yeah.
I wish I knew, because I'm trying to do that myself. But it's a very, very competitive place to get into IP firms. It's just extremely competitive. So to get into IP firms, especially if you want to become a patent attorney, that's extremely difficult, because what you need to know more than IP law is you need to have a strong scientific, well, depends what industry you want to go into, but for me personally, I need to have a very, very strong scientific background. So most of the patent attorneys will have a PhD in, you know, molecular biology or biotechnology or material science, etc., or physics, chemistry, maths, computer science. Basically, depending on your industry, it's very, very competitive to become a patent attorney. But there are other roles that maybe you could get into and then work your way up, such as a patent formalities or patent administrator, or even a paralegal, IP paralegal. So if you want to step into the IP industry, you would, you know, if you have a PhD, then fair enough, you could go ahead and become a trainee patent attorney. But it's crazy. It's just like the trainee firms, they only take on, you know, 2 or 3 a year basically for the trainee role. But bear in mind, that said, although you are a trainee, there it is in the UK anyways, it's got a you know, a decent salary for something that says trainee. So training takes about, they say 2 years, but they say it actually takes around, you know, 4 or 5 years. And what I've read on you know, IP forums is that if you have never failed anything in your life, get ready for failing the the patent attorney tests. That they say if you've never failed anything in your life, you pretty much are bound to fail it. That's how difficult they are. So basically, although it's a minimum of 2 years, most people do take 4 or 5 years to complete their training. So you get a trainee, then you get part qualified, and then you get newly qualified, and then it just goes on and on from there until you can become a partner. And like I said, even though you are a trainee, you get you know, a very good salary. Part qualified, you get even better salary. Newly qualified, even better. And then senior, and then partner. So the salary just gets better and better, basically.
Yeah, and maybe in this IP, there's probably a bit more scope, I think, in the United States than in the UK or so. Um,
Um, I think the most thriving places for intellectual property right now is China, Japan, and India. So that's where most of the inventions are coming out from. Um, so that's, you know, the US has obviously always been big in the in patents and intellectual property, but the most upcoming places now are China, Japan, India, you know, that side of Southeast Asia, or you know, Eastern Asia, basically. That's the most they're the you know, the best places that are thriving, upcoming, uh, because that's where most of the innovation is taking place. Um, and then you know, if there's an innovator, you know, person with a new patent in China, he can obviously go to the US and or the UK and make an application there as well.
but if there's a youngster here who's going on to sixth form to study A levels and who's quite interested in what you
Hmm.
just said and what advice would you give to a youngster who's studying A levels and is thinking
To a
of doing
youngster who's going
IP?
into A levels, uh,
Is it
sorry, I
worthwhile
didn't get
going?
that. I think it
No,
kind
I
of cut
mean,
off.
yeah, to do studying, and then he or she wants to go to the university to study what you've studied into like IP, and
Hmm.
then hopefully get
Yeah.
into some kind of a profession in that.
Okay, the thing with IP is it's not one route. So basically, you can become an IP lawyer, which is totally different to a patent attorney. So for an IP lawyer, you need good law. So obviously you need to do I forgot what they're called. You know, the undergraduate in law, and then maybe even a master's in law, LLM
LLB,
and LLB.
LLB, yes.
Yeah, LLB, LLB, and maybe even an LLM. And then you can be an IP lawyer, but that's totally different to a patent attorney. So for a patent attorney, it's best you go into the science aspect. So whatever field you want to go into, so there's a few fields for IP. The main ones are the pharmaceutical, so biotechnology, life sciences, and then there's physics, there's computer sciences, maths, etc. So the best thing, if you want to become a patent attorney, the best thing is to get a strong scientific background, and all the IP stuff you learn once you become become a trainee patent attorney. So all the IP you will learn on the job. So it's best that you have all the scientific knowledge beforehand. So a bachelor's, a master's, a PhD. PhD is obviously that's where you have most of the chance of getting into a trainee patent attorney firm. For a trademark attorney, you don't really need any specific subjects. So for a trademark attorney, because you don't need a scientific background or a computer science or IT or maths or anything. Anyone can basically become a trademark attorney if they have the skills for it. There's no academic requirements. I don't think. It's basically any university degree. You can become a trademark attorney. But then the trademark attorneys, their salaries are not as high as a patent attorney, and they're a lot easier to get onto as well.
Yeah, somebody has written something here. It is important to do an LPC if you want to be an IP lawyer. I have recently graduated with an LLB, but I'm rather lost as to where to go on from there. This area is one that I am interested in. Okay. Okay, Professor Ahmed, do you want to come in? And
so we had a student in physics last year who completed an MSc in physics, and then he went to work for this IP firm, and his salary was more or less double what a normal physicist gets as a physics technical job.
Yeah, I can imagine. Yeah. So even as a trainee, his salary was double.
Yeah. So his salary was double. Yeah, so a lot of students from our course, they were saying, no, I want to get into IP because the pay is so good.
Yeah, it is. It's very well paid.
You need to be good at the technical side, know a lot of,
definitely.
You need to have very good technical knowledge. At the same time, you need this legal awareness and stuff to be able to thrive in that.
Yeah, of course, definitely. Yeah. Yeah, definitely. Like I said, most of the applicants would be PhD students. So the stronger your technical background is, the more chances you have of becoming successful at your patent.
If you're a pharmacist and then you go and do a legal degree and you work for pharmaceutical companies in this particular area, again, you'll make a lot more. Mm-hmm. It's a lot better paid than being just a pharmacist or just a...
Oh, yeah, definitely, yeah. Yeah, definitely, 100%.
So you need to be multi-talented to be able to make...
You have to be that's why the salary is so good, because you need to have excellent English writing skills.
Yes.
Because patents are very, very intricate. So you need to be able to basically write the patent in the simplest way possible, but then it's very difficult. So you do need to have very, very good English writing skills. You need to have good oral skills as well. So reading as well, so that you can read all the patents and see if it if your new application would infringe the old patent. You need to have a lot of scientific background. You need to have legal awareness. So there's a lot of skills. You need to be commercially aware as well. So there is a lot of aspects towards becoming a patent attorney, and that's probably why the salary is so good. It's because it's so many factors coming into play. So you need to find all these qualities in one person. So that person, that's why the salaries are good.
I used to work for a company called VSW Scientific. They made scientific instruments, and we had a potential to get a multi-million-pound order. And the problem we had was that there was a US patent in this particular technology. So one of my consultants was Sir David King, who became the chief scientific advisor for the government once, and we spoke, and Sir David King was an expert in that area, and between us we thought we can, the patent doesn't cover what we want to do. So we can find a way around this patent and take on this multi-million-pound order. So when I spoke to the chairman of the company, Don Whitehead, I said, look, I've spoke to Dave, we can overcome this issue and let's go for it. We'll get this multi-million-pound deal. And his assessment was, no, I'm not doing that. And I said, why? Because don't you trust us? He goes, no, every time I go to court in America, it's going to cost me £100,000. Even though you can break it and overcome it, just to go to court, it's going to cost me £100,000. Yeah, if I go to court 3 or 4 times, yeah, it's going to cost me too much, yeah, to make this order viable. So that just ensures your point, yeah. If you got a patent, it stops companies coming in and using that idea, even though you've only vaguely covered some aspect of it. So the chairman was put off while the scientists were saying, oh yeah, no problem, we can overcome this, yeah. And he said, even if you win, going to court, I'm going to lose.
Right.
So,
okay, thank you.
It's a very fine line between trying to, because it's all money, isn't it? You know, like for companies, it's waste money. Going to court and being tied in a legal battle and stuff like that. So you get some kind of protection. But in the old days, they used to have patents in the UK, and some companies from abroad used to come along, and they used to just use the technology because the laws didn't apply over there. So it's difficult. So the hard thing is not getting a patent. The other hard thing is policing a patent to make sure that people are not using it and you're not benefiting from it.
Yeah.
So even policing a patent is very expensive.
Okay.
Yeah.
Okay.
There's a lot to think about in your patent application.
Yeah.
Okay. Thank you. Thank you very much, Mohammad Hassan, for an excellent lecture, your talk on IP. And thank you to everyone for listening in on Facebook and also joining us on Zoom. And hopefully we will upload this talk on our Young Professional Society YouTube channel as well. And those youngsters who are interested in what Mohammed was talking about today, Mohammad Hassan is actually a professional member of the Young Professional Society. So if you have any concerns, any questions or so, please do get in contact with us. And this is the idea we have of Young Professional Society, is that we have memberships here. So we have professional members. So within the professional members category, we have some junior members, we have some senior members, and the idea is to network together and help each other grow in our professional careers. So I would like to thank Mohammed for his time and for giving us an insight into IP, intellectual property. I'm sure everyone who's tuned in or who's listened in have learned something. And thank you very much once again, and I hope you all keep safe. Thank you. Thanks for joining.
Thank you very much.
Bye-bye. Bye-bye.
Bye.
Bye.